It's time to enter the twilight zone of patents for computer programs, computer-related processes, and internet business methods. And I think I will split this presentation into two video sessions, just to let the confusion sink in with greater effect. And you will be confused, because if you are not, then you honestly don't get it. Prepare to enter a world that makes sense to no one, and where definitive answers do not exist. But you have also arrived at the most controversial area in patent law today. And it's controversial because it's so incredibly important. Not just with computer systems as you now know them, but with the emerging wave of technology innovation related to artificial intelligence, which is fundamentally based on computer algorithms and computer processes. And those developing these systems have a lot at stake and need to know whether and to what extent their innovations are patentable. So I'm going to tip my hand and let you know what I think, which is that any computerized application should be patentable as long as it is novel and non-obvious. And so in my mind, we should not be discussing whether computer programs or computerized systems are the appropriate subject matter for a patent. Rather, we should simply assume that they are, and thus evaluate whether they meet the basic patent standards, as we do for almost every other kind of useful application. So, I wish this were the end of this story, and we could just move on. But alas, we cannot. Because this is not how the Supreme Court currently sees it. And whatever the Supreme Court says, everyone else must follow. At least until Congress speaks up, which unfortunately does not appear likely. For this reason, I'm going to do my best to fill you in on the debate in this area and how the Supreme Court has contributed to the confusion. I would love to tell you that these videos ultimately will provide you with definitive tools to address computer patent issues. But that would be a stretch. But I think they might provide you with some intuitive sense of what to expect if you are seeking patents in this field. A good place to begin this discussion is with the language of the Patent Act, which actually defines what kinds of inventions can be patented. Specifically, it says that an inventor can get a patent on any new and useful process, machine, manufacture, or composition of matter. The word new is a little puzzling here because there are separate sections indicating that an invention must be novel and non-obvious. But the drafters probably just wanted to bring the concept within its holistic statement about patentable subject matter. As for useful, well, no big surprise here. If you want a utility patent, then your invention must be useful. On the other hand, if you seek protection for an artistic product design that does not contribute to the operation of the product, then a utility patent would not be the way to go. Rather, you might want a design patent, which is an entirely separate animal. The fact that one can get a patent on a process, machine, manufacture, or composition of matter sounds as if the drafters wanted the coverage to be incredibly expansive. In fact, I would say that they went out of their way to make sure it covered every kind of invention anyone could ever think of. It's not a roadblock, in a sense, but rather permission to patent any useful kind of invention that is novel and non-obvious. I mean, just think about the inclusion of the word manufacture. Indeed, we will see that when addressing the suitability of patents for biotechnology, the Supreme Court indicated that it includes everything under the sun made through human ingenuity. And in my mind, that should include computer programs. That would be the end of it. Honestly, I wish it were, because then we could just fold this up now and go out and play tennis or do something fun. But I'm sorry, we're going to have to grind on here. And the blame has to fall primarily at the top, which is with the Supreme Court. The best place to start this discussion, and probably the biggest sticking point, is recognizing that patents are only available for inventions. This means that if the subject is not an invention, then you can't get a patent on it. Which means that we have to ask, what kinds of things are not inventions? For instance, what if I spend an enormous amount of time and money to learn that a particular gene creates a specific protein in the body? Should I be able to get a patent on the genetic sequence as a reward for my efforts and to provide incentives for future work in the field? We will see that the answer is no. And the reason is because I didn't really invent anything. Rather, I discovered something already provided by nature. Thus, you can't get a patent on natural phenomena. Similarly, if after years of research, I recognize that there's a relationship between energy, mass, and the speed of light, such as E equals mc squared. As with natural phenomenon, I've discovered a manifestation of nature, here a natural law, and I'm not actually creating anything, and so natural laws are off limits too. Now, let's be clear. If I had a patent on a natural law, then I could control the use of that law in any process or product, which would be far too extensive. On the other hand, a person should be able to get a patent on a specific application that relies on the natural law. Indeed, all inventions rely to some extent on natural laws, as the Federal Circuit noted in that cable tie case. Mathematical algorithms also make the list for the same kind of reasons. They are, after all, just shorthand representations of natural relationships. The last item on this list are abstract ideas, which don't cut it because inventions are implementations of ideas and not merely the ideas. In other words, ideas are not inventions until they are actually applied in some sort of physical manner. I'll tell you an abstract idea. Dogs really like beef and will follow a person who has the smell of beef near them. If I got a patent on that idea, then I would control virtually all dog training methods that included the smell of beef. That would be inappropriate. So, here's an application of that idea. The beef is placed in the walker's pocket. Is that patentable? I'm sure you think not. Okay, sure. It's now less abstract by virtue of the pocket detail. But it's obvious, so it doesn't meet the patent standards. Or you might just think that putting beef in a pocket is still simply an abstract idea that doesn't rise to the level of an invention. So, how about if the invention is a process to place the beef in a plastic bag and then put it in your pocket? It's a useful application because now your pants won't get soaked with beef juices. However, it's still pretty abstract, and of course, it remains obvious. Well, what about putting the beef in a bag with defined specific air permeability characteristics that allow for odors but not moisture leakage? Now we're getting there. This is certainly not abstract and might be a novel and non-obvious application of the notion that dogs love beef. You should begin to see that the fundamental initial question here is, where do you draw the line between what is considered an abstract idea and what is a potentially patentable application of that idea? If the idea is too abstract, it is not considered an invention and so is not patentable under any circumstances. However, once you have crossed the line and the idea is no longer abstract, then you might have an invention, and so the question is whether it is novel and not obvious. Are you confused? I sure hope so. And it's not going to get better because these line drawing problems are very prevalent in the context of computer programs and internet business methods. For instance, at the beginning, computer programs were viewed as number crunching machines that ran data through mathematical algorithms and displayed output. This made them suspect since they didn't do much more than solve equations. Now, of course, programs do more than that, and thus have probably crossed the line into the realm of patentability. But when does that happen? And what must they do? Business methods raise the same problems because many people view them as little more than abstract ideas that are too simple to be worthy of patents. Also, given their role in business enterprises, entrepreneurs are likely to adopt them even without the incentives from patents. Okay, well, before asking whether computer programs and business methods are too abstract or simple or whatever to merit a patent, I just want to give you some examples of a few processes in the more traditionally physical world that the PTO has found suitable for patents. And while doing this, I can show you how to look up patents and give you an idea of what you will see. The first example is a method to exercise a cat. Okay, so here I am on the Patent and Trademark Office website. And so what I want to do is obviously go to patents, and I want to search for patents. And so this gives me a lot of information here about how to conduct the search and links to places that are useful. And then in the middle of the screen here is actually the databases that you would use to search for patents. And I wish I could put on the drawing tools as we go here and circle things and point to them. But I've learned that if I do that, at least on the fly, then I can't manipulate the website. So I'll try to talk you through it a little bit. Anyway, there are various ways to search for patents. Now, I happen to know the patent number for this patent, so I can do a patent number search here. And so that patent number is 5443036 was the first one about the cat. And so I should be able to then search, and there we are. Although it looks like I've cut some of it off here. So the application was filed. Kind of have to look down below abstract, and you can see the inventors, and the filing date is November 2nd, 1993. And then up here in the top right, although I think it's going to be cut off a little bit, we'll see that the patent was granted on August 22nd, 1995. Now, this is before the Patent Reform Act. So the patent lasted for 17 years after the issue date. That's the way it was done back then, which means it expired in 2012. Now, under the new law, of course, the patent would have expired 20 years after the application date, which would have been in 2013. In any event, if you think this is a great invention, go for it because the patent has expired. So I chose this patent because it's really short and easy to grasp. So first here there is this abstract, which provides in a patent application, and in a patent it provides a brief overview of the invention. And then this is followed by the claims, which are the most crucial aspect of the document because they define the scope of what the patent owner controls. After the claims, we see sections that serve to describe the invention and its background in sufficient detail so that one skilled in the art can make it. So that's what all this
that follows is, and that's the end of it. So it's pretty short for a patent. Um, so, so I don't want you to get the wrong idea from the simplicity of this invention. Drafting a good patent application is a difficult task that you typically should not attempt to complete without an experienced patent attorney. That is really why I'm not going to spend a lot of time with you focusing on the elements of the patent application or how you might do this yourself. But the crux of the matter is with the claims, and you really have to know what you're doing when constructing them. Okay, so here's the deal with this invention, which is to provide exercise for a cat. You basically take a handheld laser pointer and wiggle the beam on the floor in front of the cat. And that causes the cat to chase it. So notice that even with this simple invention, there are several claims here. The first claim is the broadest, meaning that it will cover the greatest number of ways to solve the problem. However, the broader the claim, the more likely it is that the PTO examiner or others who later challenge the patent might find relevant prior art. For instance, perhaps somebody has already publicly disclosed exercising a cat by wiggling a laser, but didn't do it with a particular type of apparatus, with a defined beam, wiggled at a noted speed, and or within a specified distance from the cat's paw. So the PTO examiner might reject the first claim or claims, but allow some or all of the subsequent ones. Without that option, the examiner would simply have to reject the whole thing. And the same goes when others challenge an issued patent. They may end up invalidating the first claim, but the list of options means that others could survive. Thus, this is a technique to obtain the broadest coverage for a patent without jeopardizing loss of the whole thing if you try to reach too far. From this, I hope you can see that this really is an art form that requires expert attention. So look, the patent examiner approved all the claims in this application. I don't know about you, but I just kind of rolled my eyes in disbelief when I found this. Really? You might dare to reject applications for business methods or computer programs, but grant something as simple as this? I mean, if wiggling a laser to exercise a cat is not an abstract idea, then what is? And you know as well as I that people have done this before, but I guess the PTO couldn't find any tangible evidence of it. Anyway, the PTO issued the patent and it remained valid for the full term. Now, here's something I'm sure has been bothering you. This guy has a patent on wiggling a laser in front of a cat to induce exercise. I say big friggin' deal. If you did it, how would he ever catch you? Is he hoping you do it outside and he happens to be on the right street corner at the right time to see you? Does he have spies inside your house? Come on! And if he did catch you, like, what is he going to do? Like, sue you for damages? Ask a court to prevent you from doing it again? Look, he may have the exclusive right to do this, but really, so what? What's the point? Well, it's hard to be sure what this inventor expected to gain. But here's one possibility. He may have been interested in selling a cat exercise kit that includes like a laser pointer with instructions. It would be one of those impulse purchases at a pet store that hangs near the counter. So there is this nuance in patent law called secondary infringement, where you can be held liable when others do the infringing. For instance, if you encourage someone to infringe a patent and provide the means to do so, then you might be held responsible when they follow through. Thus, if others dared to sell laser kits intended for exercising cats, the patent owner might credibly threaten to sue them for unlawfully inducing patent infringement, which would certainly put sand in their competitive gears. Okay, I've put up here another patent that I found interesting as a longtime tennis player. So, if you play the game, you know there are times when your opponent hits a really good shot that you run hard for, but it's going to be just out of your reach. You know, you could get it though, if only you could take a flying leap for it. But, of course, if you did, you would land on your bare knee and, that would hurt. Well, this invention provides a process so you can make this shot without getting hurt. What you do is put on a knee pad. Then, when you need to get that extra reach, leap forward to land on that knee, and either just before or when your knee impacts the ground, hit the shot. That's pretty much it. I swear. And the PTO granted the patent. So here I'll take this down a little bit. Here are the claims. But if you look at these claims, you'll see that the broadest one basically is exactly what I said. And then the subsequent claims actually are a little bit more specific. So, yes, the PTO granted this patent and granted all of the claims, even the broad one. You know, fortunately, it expired in 2016. So we can all do this now without fear of reprisal. Of course, even before the expiration, I doubt that this inventor had spies looking for violators. As with the cat laser, I imagine what he wanted was to market knee pads to tennis players wanting the extra reach. And so the patent might have given him leverage to stop sales of similar knee pad kits, tennis knee pad kits, that were sold by competitors. So I have other examples on this list of pretty marginal, dare I say, stupid patents. And I've decided not to show you any more of the patents on the Patent and Trademark Office website because I think it's probably hard to read and was cutting off some of them. But anyway, the next one that you can go and look up yourself since you know how to do it with the patent number and using a patent number search is a process to eradicate mosquitoes. And so when you read that patent, if you look at it, what you do is you fill a bucket with water and then you wait for mosquitoes to lay their eggs in the water. And then you empty the water from the bucket before the eggs hatch, thereby destroying the offspring. My goodness. Now, he also included in the patent an apparatus that performs the process and periodically empties itself automatically. And my guess is that was his prime objective, but still, the PTO granted the patent on the simple process of dumping out the water by itself. So, filling up a bucket and throwing out the water, that's appropriate subject matter. And according to the PTO, it's novel and non-obvious. I want you to keep that in mind when we consider computer-related processes. Okay, this next one here is pretty fun. Oh, I just tried to draw a line and it didn't. Because I didn't turn. Here it is. There. I can learn. Anyway, this next one is pretty fun, I think. Unbelievable, but fun. Um, so it's a method of painting with a baby's bottom. Honestly, I couldn't make this stuff up. So here are the steps. First, put a protective covering, like a plastic sheet, over a table to protect it from the paint. Then put your desired media, such as paper, on top of the plastic. Now, put a large bowl on the plastic and fill it with paint. Pick up the naked baby, place its bottom in the bowl, in the bowl of paint, and then pick it up and place the baby bottom on the paper or whatever you're using as your media. Yep, you're making baby bottom stamps, and this process is worthy of a patent. Well, these are all pretty silly, and it's hard to believe that anyone needs the incentives of the patent system to develop or disclose them. Yet, the PTO grants patents for these kinds of inventions all the time. So, the question is, why do we even hesitate when addressing such things as internet business methods? Why are they too simple or not appropriate when these are approved? Again, where do we draw the line? A little bit later on, we will look more closely at business method patents, and so you will see several examples then. But just to give you a taste of what we are talking about, there is, for instance, Amazon's claim to a one-click ordering process that essentially records your purchasing information so that you can automatically reuse it when you return to buy something else. That system was the subject of patent litigation with Barnes & Noble, which I will have you read about. Oh, while I'm thinking about Amazon, the company got a patent on a system that used your purchase history to predict when your friends might be having birthdays. It then made gift suggestions which were informed by your previous orders. So these are process steps that are abstract ideas in one sense, but they are implemented with physical computer hardware. They seem a lot like the tennis stroke, a simple idea carried out with a physical knee pad, or the cat exercise method using a laser. All right, I'll fill you in on one more here just to drive home the point. I actually think this may have been pitched on Shark Tank several years ago. Anyway, here's the deal. You want to be more socially active and want a way to meet new people at a bar, for instance. So you go to a website, such as the one the inventor, Lori Cheek, set up. It's called cheeked.com, CHEEKD.com, and sign up for the service. The website issues you physical cards, which you can give to individuals at the bar as a kind of icebreaker. They would say intriguing things like, act natural, we can get awkward later, or don't overthink this, or emotionally available. Pretty corny, I know. On the back of the card is a code and instructions to submit it at cheeked.com. And if the person does this, then Cheeked can match the code to your personal profile and provides a way for him or her to follow up and contact you via the website if they're still interested. If you go to cheek.com, I believe you will find that it has now evolved into a system that relies on smartphones and Bluetooth instead of the physical cards. But actually, I haven't checked to see if there's a follow-up patent that covers these aspects. Anyway, these are business methods that use computers for implementation. And, I think that's enough of an introduction for us now to dig more deeply into the debates about patents and computer systems. And the best place to start, I think, is with the landmark 1981 Supreme Court decision in Diamond versus Diehr. This case actually opened the door to approving patents for inventions that included computer operations. Before it, the presumption in the courts and the PTO was that computers simply solved mathematical equations, and so technologies relying heavily on them were not patentable. This was the initial fate that befell Diehr and Lutton, which had created a machine involving a computer that improved results when curing rubber. The PTO denied the patent because the steps were carried out by a computer, and the case then made its way all the way up to the Supreme Court. The interesting thing about studying inventions is that you get to learn about things that otherwise would never have crossed your path. So, what we learned here is that the perfect cure time for rubber depends on several variables, such as the heat of the press. Also, mathematicians have constructed what is called the Arrhenius Equation to determine the best moment to open a molding press. The problem is that a press heats up when closed, and as the temperature changes, so will the optimal cure time. This led to a lot of guessing in the curing business, and it often led to poor results. Diehr's solution was to add a computer to the system to remove the guesswork with the calculations. Essentially, when the press was closed, a monitor would continuously measure the temperature and feed each reading to the computer. The computer then would calculate and recalculate the Arrhenius equation until the elapsed cure time matched the solution to the equation. And bam! The computer would send a signal to open the press. So you can see that the invention depends heavily on the computer, which inputs the temperatures, solves the mathematical equation, and sends a signal to open the press. Nevertheless, the Supreme Court determined that the system was patentable subject matter. Diehr was not attempting to patent the Arrhenius equation so that nobody else could use it. He also was not simply requesting exclusive rights to solve the equation with a computer. Rather, his invention utilized the equation and a computer, along with the other steps and components in the system, to achieve improved performance. The Supreme Court thus ultimately determined that a patentable process can be defined as a series of steps that transforms one thing into a different state or thing. Here, Diehr's system transformed synthetic rubber into cured rubber, which met the definition. The court also ruled that the process did not become unpatentable simply because it included the use of a computer to solve a mathematical formula. I want to mention a couple other items about this. First, this was a 5-4 decision, so it was a really close call. Second, although Diehr successfully argued that its invention was patentable subject matter, it then still had to prove that the system was novel and non-obvious. It did eventually do this, and the PTO issued the patent in 1982. And finally, it bears repeating that the Supreme Court, with this opinion, ruled that computer-related processes may potentially be patented. After Diamond versus Diehr, the PTO had to modify its approach to conform with the Supreme Court's newest guidance. At first, the agency focused on the hardware components of the curing process in the court's decision, and so instructed examiners to look for very physical applications of computer programs and operations, before allowing patents on these kinds of inventions. Over time, though, the Federal Circuit, which as you remember often serves as the de facto top court in the patent arena, began to relax the forms of physicality that might qualify. So I listed two cases just to give you a feel what I mean by this. And the first one here is Arrhythmia versus Cortisonics. And it involved an invention that warned doctors when a heart patient was potentially endangered by a condition called ventricular tachycardia. In a nutshell, the invention claimed a process where you would hook up the patient to an EKG, take the last portion of the digital readout of that EKG, feed that data in reverse order through a filter, and then perform a mathematical calculation on the output to create a number. If that number was greater than a pre-specified figure, then the patient was okay. But if the number was less than this particular specified figure, then the risks were high. So, in a nutshell, this invention takes an EKG reading, does some math on it, and spits out a number. This is a far cry from the types of physical attributes that warranted a patent in Diamond versus Diehr, and a lower court determined that the invention was not patentable. But the Federal Circuit disagreed and ruled that the invention was sufficiently physical with its manipulation of the EKG signal to fall within the purview of patents. The other case that I put up here is Inree-Allopat, which was about a process that smoothed the waveform in an oscilloscope. This case followed in the footsteps of Arrhythmia regarding the physicality of digital signals, but in reaching its decision, the court indicated that a computer operating pursuant to software may be patentable subject matter. This strongly implied that a computer program that provides the instructions to a general-purpose computer might have a sufficiently physical connection to meet the standards of patentability. And indeed, this was confirmed in the Federal Circuit's 1998 State Street decision, which became the high watermark when it comes to patents for computer processes and internet business methods. Here are the essential facts of State Street versus Signature Financial. Signature received a patent on a computerized financial system that I'm going to describe in a moment. Signature then learned that State Street might be using the invention in its operations, and so Signature threatened to sue State Street if it didn't stop violating the patent. State Street believed that it was not violating Signature's patent rights, and so it took Signature to court, asking the judge to declare Signature's patent to be invalid, and thus stopping the threats. The grounds for its request were twofold. One, that Signature's patent was for a computer program that did nothing more than crunch numbers. And two, that the invention was a business method that could not be patented. In a nutshell, the invention was a computerized system that helped financial institutions improve the efficiency of managing several mutual funds. For those of you that are not familiar with mutual funds, they are ways for small investors to diversify their holdings of stock, which tends to reduce risks from market fluctuations in individual shares. For instance, Fidelity might start a mutual fund that purchases stock shares in a breadbasket of different companies. And so investors in the fund actually own a small piece in each of those companies. Companies like Fidelity also typically offer different funds that focus primarily on particular sectors, such as growth companies, technology firms, utilities, or international ventures. They might even have different growth funds with slightly different growth objectives. And so each will own different percentages of stocks within the growth category. When all is said and done, Fidelity might manage a very large number of different mutual funds with their own particular investment goals. But here's one thing to consider. Fidelity's investment managers who make decisions for these individual funds might believe that it's appropriate to own some Apple or Facebook stock for a wide variety of objectives. Funds that focus on technology might take a greater percentage stake than those with more general growth objectives. But many of the funds will want to own at least some shares in these companies. And looking at this from 10,000 feet, when Fidelity believes that a company, such as Tesla, becomes more attractive, it is more efficient for the company to administer stock purchases in bulk for several relevant funds and then parcel out the ownership stakes to each fund. Likewise, if Tesla loses favor, it's better to administer the sales of the stock from the several individual funds together. Signature's invention was a system to facilitate the accounting of these transactions. It contemplated a hub to make the common purchases and sales, and then it calculated how these transactions affected the value of the individual mutual funds, which were treated as spokes. So, effectively, this is a business method that uses a computer to calculate the value of individual mutual fund shares along with other pertinent data. In effect, the system establishes a management structure, inputs numbers into a computer, makes calculations, and provides the solutions. The lower court judge agreed with State Street that the PTO should never have issued a patent on this system because it used a computer to merely crunch numbers, and in addition, the judge said that it was an unpatentable business method. On appeal, the Federal Circuit disagreed with both conclusions. So, regarding the first issue, the Federal Circuit ruled that calculating numbers through a mathematical algorithm on a computer is patentable if it produces a useful, concrete, and tangible result. And here, the share price was tangible, and the result was useful to the mutual fund industry, so the hurdle was cleared. As for the patentability of business methods, the Federal Circuit ruled that business methods are no different than any other type of process under the Patent Act. That is, if you can get a patent on exercising a cat, there is no reason to exclude protection for far more complicated and useful systems just because they facilitate the operations of businesses. Thus, at the end of the day, Signature's invention was patentable subject matter, even though it only effectuated a business method on a computer. And so you can see why this is a high watermark for patents in the computer industry, because the subject matter restriction was pretty much obliterated in almost all contexts. Based on State Street, as long as a computer-implemented system was novel and non-obvious, it could be patented.
Well, I think this is a good point to end this video. As you can imagine, not everybody was happy with this result, and it certainly did not end the debate. As a consequence, a few years later, the Federal Circuit backed off a little bit from its sweeping State Street decision. In addition, the Supreme Court stepped in and only managed to make the confusion more confusing. So stay tuned.